September 22nd meeting of the Board of Public Works and Safety. Roll call. Here.
Here?
Here.
Are there any conflict of interest statements?
No.
Approval of the minutes of the September 15th meeting. Did anybody have a chance to review those? No?
Motion to defer action?
Second.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Move down to correspondence. Item A, order submission forms from First Communications for telephone service at Central Fire Station. Did somebody review these? It looks, no.
Yeah, Mr. President, the IT department has informed me that they're looking into getting more lines with a different carrier, and then this is just basically the request to seek those proposals. It's not a contract at this point in time. And unfortunately, there's about 900 places where you have to initial. And this is both for the Civic Center and the Gene Shepherd Center, or I'm sorry, Central Fire Station and the Civic Center.
So you want us to basically approve this at this point?
It's not the contract.
Okay. Do we have a motion?
So moved.
Second.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item B, correspondence received from 5th District Councilman Dave Warple requesting $25,000 of gaming funds to be allocated for use for the Park Department improvements submitted for approval. And it's already been approved by the mayor, and we have Dave Warple's signature on it.
Motion to approve?
Second.
Motion and second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item C, status of demolition hearing on property located at 4409 Johnson.
Is the owner here? Yes. Oh, come on up here. Mr. President, if you will recall, this was the removal of an illegal apartment. It went as far as an order. That order was appealed. That order was appealed to the Indiana Supreme Court, who reversed the circuit court and said that the board's order should stand. So the order that is before this court, which was affirmed by the Court of Appeal, not taken up on transfer, of course, is that the unit should be removed. This was originally set for a hearing, I think, in July. Mr. Alcantar was going to be out of town, and he asked for some additional time. However, we're still left in the position where the unit still remains. He has not pulled any permits to remove it, and if he's not going to voluntarily remove it, then we're going to get an order, and we're going to bid it out. We're going to have somebody remove it for him.
Good morning. I was out of town for the hearing in July, but as I talked to the inspector, my intentions is that if I have to convert the property, that's what I'm going to do. I've been getting some bids. I have a couple of estimates already in place. I know, and during the research, I find out that the property had 3 tenants from the beginning. I have records of that. They still think that I should convert the property.
We've already went to court. The Court of Appeals has ruled the city of Hammond. Are you going to remove the unit, or do we have to get an order recorded on your property, which will be a cloud on your title, and bid it out and remove it ourselves?
As I say, I will be doing whatever has to be done to convert the property to a single-family home if I have to. Yes.
Yes, you have to. So when are you going to do it?
I was getting a loan and I got denied, but I just got a call yesterday that I will be getting a loan, so I have that already, the estimate from the company that is going to start. So I would think it would be done. It would start soon.
May I suggest that we get a copy of those bids so we can make sure that basic things that we're looking for to be removed, and back to the single family home are in there. That will also give us make sure that the contractors will be licensed in the city of Hammond when we do the work. We make sure that's moving properly. It's a very confusing layout. It's actually 3 units, so it's kind of a convoluted cut up mess. When we do those bids, we have an idea of what the contractors are doing and guide them.
Yeah, I wouldn't have a problem. I have a copy. You can have a copy of that estimate. The only estimate that I have right now is for the demolition of the property, because they would not give me a code, because they say they have to first look and see what's behind the walls in order for them to give me an amount of how it would cost to redo it. But I do have the estimate for the demo.
After that demolition of the walls, after the demolition of the walls, very likely we'll need architect drawing on what the floor plan's going to be, and also then we code, curve code. So, mine would be the estimate, guys like
the guy is,
The order entered, so we can move forward in case it stops midstream and we're starting over.
the guy is licensed, I got his name from your list, so.
My only concern is we do enter the order, it will probably be recorded as a demolition order on the property, and that might affect his ability to get a loan, which is why I'm pushing for him to do this voluntarily, because once we start getting involved, it's gonna make his life a lot harder on this. So we do have demolition status in October 27th. We could set this over to October 27th. If he voluntarily is complying, we won't have to do anything that will adversely affect the title of his property. If he's not gonna voluntarily comply, then we're just gonna enter the order on the 27th. Can you get it done by October 27th?
Look, the loan is not, they're not gonna give me a loan to do anything in the property because, they don't think it's worth, to do that. I'm getting the loan otherwise.
October 27th?
I'll make a motion to set this for status on October 27th.
We have a motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. I'd like to recognize Councilwoman Janet Venez and Councilman Pete Torres in the audience. Item D, notice of violation hearing for property located at 1514 Roberts.
This
Jose
property,
Rosado.
this property is going to be having a deed restriction filed. I still have to get to the owner's property to pick up the signed copy. If we could please set this over to September 29th, next Thursday, which will give me opportunity to get the deed restriction, then submit it to the board for approval.
A motion to set to September 29th.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Motion passes. Item E, notice of violation hearing for property at 2319 New York Avenue.
This is a two-unit property. Based on research and findings, it has been determined that the second floor unit was created without permits or fire separation and doesn't meet minimal code to be used as a separate apartment. The owner is cooperating and complying with our request for removal. He already has a general contractor, any electrician who has pulled permits and has begun work to remove the apartment. So I just ask that the board affirm the removal and we can let the owner continue to bring his property into compliance.
Do we need a status on this?
No, if we could just affirm it and then accept the findings and orders, then we'll be good. The contractors already have begun construction, so the final inspections will determine the removal was complete.
Make a motion to affirm the order.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Aye. Those against, motion passes.
Thank you.
Item F, correspondence received from Chief of Inspections Kelly Kearney recommending that the board throw out the bid of Grimmer Construction at the contractor's request for 1046 Kenwood Street and award to the next low bidder, RSR Demolition.
I don't believe my exact phrase was throw out, but,
Pardon?
I don't think my exact phrase was throw out, but, however.
Well, but it's,
Yeah,
but the contractor requested you not to,
yeah, Grimmer is occupied elsewhere and, agreed to let us give this, the next lowest bidder as RSR.
okay?
Any motion on
Do I have a motion approving the award to RSR Demolition for $10,799?
that? So moved.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item G, correspondence received from Chief of Inspections Kelly Kearney recommending that the board throw out the bid of RSR Demolition for the demolition of 5853 Wallace Road and award to the next lowest, most responsive and responsible bidder, J&M Industrial Services.
And just for explanation, there was some asbestos removal that was required in this. RSR did not put it in their original bid. When they gave us an estimate on what it would cost for their asbestos removal, it took them over the JM's bid, and JM's bid did include the removal of the asbestos.
So their bid was incomplete.
Correct. Once they put it in, it took them over to,
Do I have a motion recommending the award to
Jam.
J&M for $9,300?
So moved.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Motion passes. Item H, Order to rescind order of demolition on property located at 1023 to 25 Kenwood Street submitted for approval.
I received photographs showing that the property was like a shack in the back of a property. The structure has been removed. And so we need to rescind it so that we can record it on the property.
Motion to rescind the order to demolish.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item I, agreement to rehabilitate property located at 1510 173rd Street, fourth extension submitted for approval.
This might take the record for the slowest progress we've ever had on a rehab. However, progress is steady and continuing, and it is nearly done. And so we're just extending it basically through the rest of the construction season for this year.
Sullivan? Okay.
All apart.
I'll make a motion to extend the rehab agreement.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item J, disposal authorization submitted for approval. These are, looks like some pretty junky vehicles.
Okay. Make a motion to approve.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item K, correspondence received requesting rental registration hearings. What, there's two here? Or there's just one?
When do you want to set it?
20th?
Motion to set rental registration hearing for October 20th.
Second? Okay. Those in favor say aye.
Aye.
Those against, motion passes. We have garage sale permits, a bunch of them.
You do? Sam and the address?
That's in Robertsville.
Okay. Motion to approve the garage sale permit.
Motion to second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item M, correspondence received from Second District Councilman Pete Torres requesting $2,850 of gaming funds be transferred to pay for the removal of 4 trees and grinding of tree stumps.
This was previously approved by the board, and we had an additional amount of work to be done, so there was one extra tree that got removed as part of this work.
These are on Ash Beach, Elm, and Johnson.
Yeah, there are four locations, I believe.
Yeah, I would like that be amended to 4 locations instead of 43. There were a total of 6 trees, I
Yeah,
believe.
yeah.
Motion to approve the request.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.
Those against, motion passes. Item N, correspondence received requesting $40,000 of gaming funds from the 5th District be transferred for an overlay on White Oak Avenue from 175th to 176th, submitted for approval.
Motion to approve the request.
All right. Oh, sorry. I wanted to apprise the board before we got to matters from board, matters from department heads. We do have some council present. If you'll recall back, and I believe it was August, we had tentatively set a date today for a hearing on a property. It was a tentative date because it was contingent upon an inspection being completed. However, we do have Attorney Vossi and Attorney McNamara here on that matter, and so I just wanted to have it added to the agenda as item O. It's a hearing on property. Bless you.
Okay. Did we get a motion on that last one? The $40,000?
I did a motion, did we approve it?
Yes. So now we move down to item O. It's a hearing on the property located at, what's the,
I'm sorry, 6609 Jefferson.
Jefferson?
If I may, my name is Kevin McNamara. I'm litigation counsel for the city of Hammond. This matter goes back to the spring of 2013, at which time notice of violation was issued and presented to the Board of Public Works. Over the course of a couple years, the matter lingered. Finally, in May of 2015, there was a hearing without Mr. Andrade present, and the board issued a findings and decision at that time. Mr. Andrade, through his counsel, appealed that to the state court. There was an issue of whether notice was proper for the May 2015 meetings, and the Lake Superior Court ruled that there was a question of notice and remanded the action back to the board. Immediately following that court hearing, I contacted Mr. Bosti and said, in light of the almost 3 years now since the inspection, we'd like to get a new inspection. Of course, we have new hearing members on the board present now than were present back in 2015 when this matter was heard. And if the current board is going to rehear this matter, we want to assess the current situation of the property. We set a date for a hearing on September 22nd today, with the understanding that that inspection would be completed. It has been completed, however, Mr. Cook has not yet finished his report. At the inspection, which took place on September 8th, I knew that the tight time frame would be an issue because proper notice is required under the Indiana Unsafe Building Act. And I had a personal conversation with Mr. Bosti at the inspection, said we probably will not be able to proceed on September 22nd because of the time necessary for inspection, or for notice. We discussed October 13 and October 20 as possible dates. He said he was available for both those dates, and on the same day I advised Chris Cantar that we had agreed to move the date to late October because of that. Mr. Bosti, I'm sure, will describe that he sent me correspondence soon thereafter suggesting that the inspection should be a separate matter from that of the court action. We completely dispute that. There's no reason for me as litigation counsel to seek an inspection on a separate matter. This is exactly the same matter that was proceeding from spring of 2013 that was addressed by Judge Hawkins in Lake Superior Court 2. It is now being presented back to the board. Upon Mr. Cook's completion of his report, we would ask that the board hear the matter at that time, consider all the evidence at that time, and that no hearing take place today. I know that Mr. Illingworth is here, and Mr. Bosti will discuss that, I'm sure. We would object to any testimony be taken today, and for those reasons, I would request that the board continue this matter to October 20, at which time we can address it all in one hearing. Thank you.
Good morning, Board. I've been before you a number of times on this. Kevin certainly has recounted the lengthy time period of this. However, I want to remind the Board that I was here before the Board. Judge Hawkins ruled June 23rd that our appeal was granted. He remanded it here for further proceedings. I appeared before the Board on July 7th. Told the board that I'd been contacted about a new inspection, that I would oppose that, and that our position was that, and then I was here again on July 21st with a motion before you all to the scope of what this hearing is all about on remand from the judge, from the Lake Circuit Court, Lake Superior Court, excuse me. There was the issue of a new inspection that they brought up. I opposed it. They did not
bring that up to the judge. They did not bring it up to you despite you've had maybe 12 hearings in this time frame. Instead, they went to Hammond City Court to get the new inspection. And the judge read us the Riot Act. We agreed, okay, judge, we'll allow the inspection. But our position is that's fine, that's a new inspection. The September 22nd date today that was set was for the remand from the Lake Superior Court, which says for further proceedings. My motion to you on the 21st of July was that the remand means further proceedings. The proceedings ended, which was the issue of the appeal. It ended with the presentation of the city's position. We weren't here, we didn't have an opportunity to cross-examine, we did not have an opportunity to present our own case. The judge agreed with us that that was unconstitutional and ordered back here for remand with further proceedings. Our position, and as we've said to the board, is that we should pick up either, there's options that you board obviously have. One is to agree that our petition was accepted by the judge and it was granted, which was that this case should be over. So you can say, okay, fine, this case is dismissed, the one that was begun March 13th, 2013. I believe that was the date, in 2013. Or our position is that this hearing that was May the 14th of 2015, at which we were not here, in which the judge ruled you guys were wrong to have it without us, should pick up from where they left off. The city presented this case, we should be able to cross-examine and present our case. So we would, and we asked for a ruling on that. I think it was Chief that said that, you know, you wanted to make sure Mr. Illingsworth would be here, and I said I'd let you know if he wouldn't be. My impression would be that he was. We sent depositions. They've known about it. It's true, Kevin talked to me the day of the inspection, September 8th, which was enough time. They wanted 10 days before this next hearing. If they wanted to present it here, fine. It's not ready, that's fine. They can bring that, but that's a different proceeding. Madam Commissioner, I think that you would appreciate the fact is what they're asking for is a second bite at the apple. They want to start all over again with a new inspection. Fine. They have a right to an inspection, but the proceedings from 2013, the city brought, and let's not forget, when the city in 2013 inspected, they put a red tag on the building. They wanted the people to evacuate immediately. So we've had that on our heads since 2013. We have fought it successfully in court and appealed it successfully here for a hearing. So we would like that hearing to complete. They began the hearing, we'd like to complete it. And at the very least, if this board decides not to have the hearing today, or decides not to dismiss the case from 2013 so they can present a 2016 case, which they indicated they were going to have before they even inspected the house. So they went into the house feeling they were going to come up with a notice of violation, which I would question. But nonetheless, I would ask this board to rule on my motion that I presented to you that you said you would rule on today. And at the very least, Mr. Illingsworth, who is the state's top building law officer, has come up here a second time to this Northwest Indiana to testify here. I would ask that you allow him to testify. I would keep it brief, I would say it to you on that, but nonetheless, you have a choice. Thank you.
I may respond briefly. Mr. Vosti has suggested several options, the first of which is that this board would take the court's action as instructions to completely dismiss this action. I think that's a mischaracterization of the court's action. The court ruled on an issue of notice. The court did not address any of the substance of the board's action. So I would dare say that first option is not a proper option for this board to consider. The second option Mr. Vosti suggested is that the board pick up where the previous hearing left off. I also would say that that is not a proper option for this board to consider. There are two different hearing members that were present on the board back in May of 2015, and to suggest that we just skip the presentation from the city and pick up with the presentation from Mr. Andrade and his attorney would not give the current board members a proper presentation of the evidence for their consideration. As for this third option, maybe fourth option put together, having Mr. Illingworth testify in sort of a piecemeal fashion, I again would object to that. I would say that that's not the proper way for this board to consider the evidence on this matter. Proper way to consider the evidence on this matter is to wait for Mr. Cook's report, which is not a second bite at the apple, but is a current assessment of the premises for the current board's consideration. It is not a different proceeding, it is the same proceeding, which is why litigation counsel was the one who scheduled the inspection with Mr. Vosti and not the inspection department. I have no dealings with new proceedings. I'm here to continue the litigation that was begun previously. So with that, I would renew my request that no hearing be had at this time, that no testimony would be taken at this time, that we continue until October 20, at which time this matter can be handled appropriately and completely. Thank you.
A real quick rejoinder. Mr. Andrade's been waiting for justice on this matter since 2013. This matter went before this board without us to give you an idea of what our case was and to cross-examine their case. This board chose to go ahead and rule without us here. We appealed that to a higher court. The higher court said you were wrong, ordered a remand with further proceedings. When is Mr. Andrade going to get justice on what was done to him in 2013? That's what is remanded back to here. We have, I mean, they took a new inspection. That's fine. They can bring that case here. But we're here on the remand from the 2013 inspection, and we would ask the board to allow us to present evidence and allow us to cross-examine the evidence that the city presented on the 2013 issue. The 2016 inspection, if it's allowed to be added to this 2013 case, is giving the city an unjust opportunity to add to its case. And that is a separate matter. They can get rid of this matter in 2013, and then they can proceed with their 2016 inspection and notice of violation, which they've already decided they were going to have. So I would just say Mr. Andrade deserves justice. For 3 years that this city has been holding him hostage. Thank you.
We need time to review it prior to, I think we need time to review it prior to anything. Any action on this? We need some sort of action on this?
Yeah, we're gonna need to make a decision whether we're gonna wait until the 20th, which I think is the right procedure. Same as for regular to proceed today.
I think we need something in front of us before we can do anything. Don't you think? Do you think we need something in front of us before we can start hearing testimony on
Yeah, we don't
something?
have, do we inspection? I'm not ready to do this today.
The board has discussed this, and because of the fact that this board is two parts new, we're unclear on even what the original hearing was being held on. I feel like it would be the most appropriate course of action to have all the information in front of the board prior to hearing any testimony so that we can review all the facts of the case and make a reasonable decision on the matter on October 20th. So it will be our motion to continue this matter until October 20th.
A motion and a second. Any questions or comments? Hearing none, those in favor say aye.
Aye.
Those against? Motion passes.
So, can I be clear, you're resetting this to,
October 20th.
and you're not going to take
I believe we don't have any information in front of us. We are even unclear on what the original situation was.
I have been to this board 3 times since the June 23rd hearing. I have given this board motions that the board said it would rule on today. I have given the board, you have all the testimony that was given before you. The only thing you do not have in front of you is the new inspection.
We have absolutely nothing in front of us.
I gave you the transcripts of the May 14th hearing. I gave those to you in July. So you have everything that was presented on May 14th, 2015, when we were not here. You have that. The board ruled. So why don't you dismiss this case and let them bring a new case?
I think we already made our motion, sir.
Thank you. We object for the record. And I would ask, since when I was here before and the chief expressed its extreme interest in Mr. Illingworth being up here, being up here to testify, that since we brought him up here at his own expense, this board will reimburse he and his attorneys for their time in traveling up here today. You were told he was going to be here. You were interested in him being here. He has taken time from his day and his attorneys, and we would ask before then.
I would ask that we go back and check the minutes, because I recall very clearly that this was only a tentative hearing date, and it was tentatively set for this date contingent upon the inspection being completed and the report accomplished, and that has not happened. And if you go back to the minutes of the July meeting or whatever it was a tentative hearing date. Mr. Vosti did not receive a letter from this board saying that it was set for hearing today. Whether he took it upon himself to move forward and to drag poor Mr. Illingsworth up from Indianapolis, despite the fact that yesterday he was informed by Mr. McNamara that there was not going to be a hearing today, or at least Mr. McNamara is going to object to one. It was a tentative hearing date. What had to happen didn't happen, mostly because of the refusal to grant the inspection, which required an action in Hammond City Court to compel it. Had the inspection taken place voluntarily and early enough, this would have been a hearing date. But you cannot sit there and drag your heels and then complain that things don't happen, which is exactly what Mr. Vosti is doing. This was a do-over that was tentatively scheduled for today. It didn't happen, and now it's going to happen on the 20th. And Mr. Illingsworth, if he wishes to drive up again on the 20th, can do so, and then we will have the hearing in its entirety. We're not going to pick it up where we left off. We're going to take it from the top.
2 quick comments, and then I appreciate the board's time. First off, Chris's recollection of what happened, counsel, I'm sorry, you can take it. It's not fact, okay? It is not fact. You guys set this hearing for all things Andrade, 6609s. And you were, Chief, you were particularly interested in the
My question to you, Mr. Vosti, was,
Yes.
are you sure the gentleman will be here? And you weren't sure, this was a month ago,
I said I would let you know
and you didn't let me know.
I let the attorneys know for the city and.
First I've
Hey.
seen the gentleman today. Know nothing about him being here today.
I'm not gonna argue with the chief. Your counsel. If they didn't tell you, I suggest you talk.
Thank you. Are there any other matters from board members? Matters from other department heads or their representatives?
I'm sorry, you did not rule on my request to give Mr. Illingsworth a per diem or mileage or whatever.
There was no hearing scheduled for today. There was nothing on the agenda, and I remember what Chris said, that it was tentative, depending on everything falling in place.
And I notified the council on September 9th when he brought up the issue of delaying it. I notified his council that it was on, that we would be here with Mr. Illingworth and what we expected from motion. The issue is with new inspection, that's a new issue. That's our position. I won't belabor it.
There any new business? Old business? Meeting's open to the public. Is there anyone in the audience who'd like to step up to the microphone? Please state your name for the record, ma'am.
Yes, my name is Greta Gregory. Ready for me to begin? Yes, I put in a request for a yard sale for last weekend, the weekend of the 16th. I had a family emergency and was unable to have my yard sale, so I'm requesting, if possible, if I can have it this weekend.
What's the address?
244 South Moore Road.
Just the one day?
For Friday and Sunday.
Friday and Sunday.
Yes,
Can you fill this out for us?
sure.
I'll make a motion to approve the request.
Yeah, just so we have all the contact information.
I'm taking it.
We have a motion and a second. Any questions or comments? Hearing none, those in favor say aye.
Aye.
Those against? Motion passes. Is there anyone else in the audience who'd like to step up to the mic?
My name is Jose Andrade. I'm the property owner at Jefferson. About 3 years ago, when after the inspection, I had started my research as to, try to answer these charges. And I called Dean and other state officials, and through other research from the assessor's office, I gathered information that my property was built as a multi-unit from day one. We had a meeting in the basement with Christine Cantor, the inspectors, and my first attorney. And I was feeling good because of all this information I had. And when I started to present this information to Christine Cantor, she turns away and says, "I'm not looking at this." I'm like, "What?" And she goes, "I'm not looking at that." I go, "What?" And I try to show it to these other inspectors, and they didn't want to acknowledge it. So the meeting went on, us talking over each other. It should have never got to this point. It's beyond, the safety issue is a smokescreen as to what's going on. I got historical evidence showing, like I said, from the Hammond Registry and Ancestry.com that my property was built as a single-family home. The information I got from Dean, the state guy over here, is if a property is built up to code as a multi-unit, there's names of who the owner is, who the tenants were. It's detailed like that. It shows if they're married. It shows where they work. It's not just, there's detailed information. So it never was built as a single-family home. And, with as far as the fire separation, the way the law reads, if a property is built up to code during the time of construction, you're grandfathered in. They can't press the issue of fire separation. And as far as no permits to convert, none would exist. Can you shut up?
Hey,
We're not
Sir.
going to do the hearing now. This is what he's trying to do. He's trying to de facto do the hearing now. We will do this on October 20th, and he can say whatever he wants on October 20th. But we're not going to do the hearing now and then say the board should have ruled on it.
Sir, excuse me, sir. Excuse me, sir. We have one person up there at the podium. We'd ask that you treat our city attorney with respect when you're before this board. We appreciate your presence here and your public comment, but it will be taken just as that, public comment.
Yeah.
This will not be considered as any kind of testimony towards the hearing,
I'm not asking
and
that.
none of that will be considered in this matter until the hearing is held on the 20th. Would you like to continue?
You do. I love it. It shows the
Yes.
kind of person we're dealing with.
Yeah, yes, it does.
Yes, it does. So this is all being taped too. You know that, right?
At what year of law did they tell you not to look at the semester?
Okay.
Huh? At what year of law did they teach you?
Sir, I'm doing the hearing now with you.
Okay, but it did happen. And,
It's all in the transcript.
no, that's what I have to say.
Thank you.
Okay.
okay, thank you. Anyone else? Yes, sir.
Good morning. My name is Juan Andrade. That is my younger brother. I'm a lifelong resident of East Chicago, Indiana. Been a community activist for actually going back to the 1980s. I co-host the Only Bilingual Talk program in Northwest Indiana called Nuestra Comunidad, Northwest Indiana. It's on Friday evenings from 5 to 6 and Saturday mornings from 10 to 11 on WLTH AM 1370 radio. I think you just noticed some frustration on behalf of my brother based on the comment that he made to the attorney here. But, and I think anyone who's been in his shoes fighting the city of Hammond on a case that should have been solved ages ago, knowing that he has all the information to prove his side right and not Hammond's side, it's a travesty, it's a disaster, and it's a good thing it is being taped right now. And hopefully it'll be shown on the internet and so forth. But it's not just his situation, from what I understand, that he's been going through this. There have been others in this city of Hammond that have been going through the same thing and have actually lost their properties knowing that they've been in the right, but they gave up because, from what I understand, they couldn't afford to keep paying their attorneys time and time again. My brother's been fortunate that he's been able to pay his attorney throughout these 3.5 years so that this case can keep going, which should have been solved ages ago. So there's a major problem. Either there's a cover-up for something, or something's going to explode at some point down the road that this board is going to help open up in the city of Hammond, Indiana. So if this was just something, one case, and he's the only one that's going through it, it's one issue. But no, I understand that there's been other landlords in this city that have lost their properties, that are going through the same thing, but only gave up because they couldn't afford to continue paying their attorneys. Thank you.
Is there anyone else in the audience? Anyone else? Do I have a motion to adjourn the meeting?
So moved.
Motion and a second. Questions or comments? Hearing none. Those in favor say aye.
Aye.